Evidence. Hearsay. A court needs to have the best evidence possible to reach a correct decision. Usually, witnesses are confined to giving evidence about facts of which they have personal knowledge. In this tutorial, we are going to look at what constitutes hearsay and how hearsay evidence may be admitted in criminal proceedings. The most common examples of hearsay in criminal proceedings arise where a witness seeks to adduce evidence of facts about which they have no personal knowledge because the facts have been passed to them by another person who is not in court. Or a party seeks to adduce as evidence a witness's written statement without the witness attending court to give oral evidence. Real evidence. Real evidence is admissible under the common law. It's evidence from which the court may draw conclusions or inferences by using its own senses. An object, such as a weapon used to commit murder, is an example of real evidence. Printouts and readings from mechanical devices can also be treated as real evidence. Real evidence is not covered by the rule against hearsay, so photographs, CCTV footage, and a reading from an intoximeter, all of which are real evidence and therefore admissible, are not covered by the hearsay rules. What is hearsay? Section 114 of the Criminal Justice Act 2003 defines hearsay evidence as a statement which is not made in oral evidence by the original maker of the statement, but which is adduced as evidence of any matter stated, i.e. the purpose of adducing the statement is to prove something by getting the tribunal of fact to rely upon the statement. A matter stated is defined by section 1153 of the Criminal Justice Act, which provides that the purpose, or one of them, of the person making the statement appears to the court to have been to cause another person to believe the matter stated, or to cause another person to act or a machine to operate on the basis that the matter stated is true. For example, in accordance with the Crown and NK, a diary note intended to be seen by the writer only was not a matter stated for the purposes of section 115, because the writer never intended it to be read, let alone persuade anyone of the truth of the entries.